Welcome to You Counsel. We sign waivers all the time. When we go for skiing, we sign a waiver. When we go for bowling, when we go for skydiving, when we rent a car. There are so many circumstances, so many activities that we engage in on a daily basis. And when we engage in those activities, we are required to sign waivers by the providers of those activities, by the suppliers of those activities. And we do this all the time. What are those waivers? When are they enforceable? When are they not enforceable? That is the topic of today's lecture. We begin with our usual disclaimer that this lecture is not legal advice. So if you have any specific questions regarding your issues, then you should talk to a lawyer or a paralegal. And if you don't know one, you should contact the Law Society of Ontario for any referrals. What are waivers? Essentially, they're also called exclusion clauses, same thing. And essentially what a waiver does is it transfers any risks of that activity from the company, from the provider to you and me, the consumer. So essentially, it takes away the company's liability for any injuries that you may get because of those activities that you're engaged in. That's what a waiver essentially does. So let's look at some of the examples of these waivers. The first example I have is Blue Mountain waiver. If you go on their website, you see this exclusion of liability waiver. This is a broad general waiver. It is on their website. And if you are on Blue Mountain premises, you will see this waiver posted at different spots at the resort. And it says, posted in bold letters, it's in red and yellow, so that the idea is that it is so clear, it is so obvious that you don't miss it. Right? Notices to all users of these premises and facilities, exclusion of liability, assumption of risk, and jurisdiction. So it's covering, this poster is covering three things: exclusion of liability, assumption of risk, and jurisdiction. Please read carefully. These conditions will affect your legal rights, including the right to sue for negligence or breach of contract, or to claim compensation following an accident. And it covers all the potential scenarios that can happen, and it basically says that we have no liability whatsoever, right? So it says, as a condition of use of the premises and facilities and your participation in activities on the premises, you assume all risk of personal injury, death, or property loss resulting from any cause whatsoever, including negligence, breach of contract, or breach of any duty of care owed under Occupiers Liability Act on the part of the operator and its employees and representatives. So essentially, and then at the bottom it says the operator's liability is excluded by these conditions, right? So once you have signed this waiver, and so when you purchase the tickets, you're required to sign these waivers, and there are some certain specific waivers with respect to specific activities that may also be applied. When you go to Blue Mountain website, there are waivers for skiing, there's a waiver for tubing, all kinds of things. So there may be specific waivers for certain activities. But this is sort of one waiver that I picked up to show you as an example. So what essentially this waiver does is that any activity that you perform when you go to Blue Mountain, when you purchase a ticket, when you sign the waiver, you cannot, if you are injured, you sustain injuries because of that activity, you cannot turn around and then sue Blue Mountain and for any liability. And notice that it includes negligence as well. So if you're going downhill on a ski slope and it was not maintained properly, or there was some debris left that shouldn't have been there, and because of that you get injured, you will still not be able to sue. So it covers even negligence. There is no warranty given to you by the ski resort that they will maintain the premises in the perfect condition so you could enjoy your skiing. So all the liability, all of the risk is transferred to the user. So that's sort of one example. Another example I have chosen is a rental car agreement. This is Budget's website I picked up. And if you notice and this is typical, you will see that in any kind of car rental agreement that this clause or similar clause is there, right? So clause 14 basically tells you what is a prohibited use of the car that you have rented. And if if you operate the car because of and you follow one of the prohibited uses, then a violation will actually terminate your rental agreement immediately, right? So a violation of this paragraph will automatically terminate your rental and is an exclusion to and voids all liability protection and optional services. So all of these optional insurance that you may have purchased for supplementary liability, for personal accident insurance, all of these are void if you engage in a prohibited use of the car. And so what is a prohibited use? It is outlined here. You use or permit the car to be used by anyone other than an authorized driver, right? So, and then authorized driver is defined in paragraph 5. So there are a number of activities that are listed here and which are called prohibited use, and if you engage in those activities, your rental agreement is immediately void, and you will not, if you sustain any injuries, you will not be able to sue the rental car company for this. And you can see here that even if you are using a handheld wireless communication device, if you're operating, for example, your phone or something to communicate, a handheld wireless device, and then you sustain certain injuries, you will not be able to sue Budget Car for that, right? So that's just an example for you of some of the agreements that waivers that we sign. It's on an everyday basis. Now, when are these waivers unenforceable? You've signed it, and now you want to know whether this waiver is going to be enforced or not. The leading case in this from Supreme Court of Canada is called Turcon Contractors Limited versus British Columbia, and is a 2010 case. And that case establishes a 3-part test in determining the enforceability of a waiver or an exclusion clause. Number 1, whether the exclusion clause applies to the circumstances in question. Number 2, whether the exclusion clause was unconscionable at the time the contract was formed. And finally, whether the court should refuse to enforce the waiver because of an overriding public policy. So if any of these conditions is met, the court may decide not to enforce the exclusion clause or the waiver at all. So we'll take the first element, the circumstances. What the court does in the circumstances case is the court looks at the specific language of the waiver, the specific circumstances that are covered in that waiver, and then looks at the circumstances of the injury and then determines whether that particular circumstance which caused the injury, was it actually covered in that clause or not. So they very thoroughly review the clause to make sure that the clause actually covers the circumstances that are being alleged now underlying the injury. So I'll give you 2 examples, one in which the court refused to enforce a waiver because it did not cover the circumstances. One was a person was on a ski resort and he slipped in the parking lot on ice and got injured. And when the court reviewed the waiver only covered injuries from downhill skiing. And so because the person was not doing downhill skiing, he was just walking in the parking lot and sustained injuries, the court held that the waiver will not be enforceable because it did not cover the specific circumstances that led to the injury. Another example is that a person was injured, and this was a person taking a police foundation program at a college. And while he was running on a track, he got hit by a basketball hoop and got injured. So the court looked at the specific waiver, and the waiver had language something to the effect that injuries or other complications associated with exercise or other physical activities. So the waiver was very specific to the injuries sustained because of engaging in an activity. So if you're running and you pull a muscle or you sustain another injury and you have to go see a doctor, that waiver was covering those activities. The waiver did not cover any injuries that a person may sustain because there was the track was unsafe to run, right? So it did not cover the negligence with respect to how the facilities was maintained. It dealt with the injuries arising from the very specific activity itself. So the very physical, engaging in that physical activity. So the court held that no, what is covered in the waiver is something different. You did not maintain the track properly, which is completely different. You could have, if you wanted to have a clause that provided you no liability or waiver because of negligence in maintaining the track itself, then you could have created a clause like that. But the clause that you're relying on does not cover it. And in that case, the court said that it will not enforce the waiver. So this sort of the review of the circumstances is sort of the most common way of enforcing the waivers, of rejecting the waivers, because the court needs to make sure that the person who was injured was that person injured because of those very specific circumstances that are covered in the waiver or not. Unconscionability is the second element. First thing you want to understand about unconscionability is that the clause itself, just because there is a clause that excludes liability, that is a waiver clause, does not mean that the clause itself is prima facie unconscionable. No, that's not. Unconscionability essentially deals with a power imbalance between parties. And what does a power imbalance indicate in case that you go to, for example, Blue Mountain? It is not a power imbalance, or not necessarily a power imbalance to say that I'm just an individual, Blue Mountain is a large corporation, there is a clear power imbalance. That's not necessarily how the court will consider it. What the court will consider it, whether you are voluntarily engaging in that risky activity or not. So nobody's asking you necessarily that you're required to engage in this activity. You can choose, you have chosen to go for skiing, you've chosen to go for skydiving, right? So that's a choice you have done. You're freely engaging in that activity. And so there is no sort of power imbalance in that relationship, right? This is not a situation where because of the significant power of a corporation, you are now required to engage in a certain activity. So that's sort of how the theme of unconscionability generally would work. But unconscionability, as I said, is a second consideration. And if you can show that the waiver was unconscionable, then you can claim that the waiver should not be enforced. The final test is public policy. A common example that I can give you is that any waivers that are relating to minors, right? So generally speaking, the public policy suggests that parents cannot give away their minor children's rights in law, in tort, by signing waivers on their behalf. That's sort of the public policy. In British Columbia, that is the law. So when a parent signs a waiver in British Columbia on behalf of a child, that waiver is not enforceable. It is likely that the same will be in Ontario, although there aren't any cases that have specifically dealt with waivers respecting children so far. But that sort of seems to be the public policy. It is yet to be decided in Ontario. So my kids go to trampoline gyms all the time, and so we sign these waivers all the time. And if they sustain any injuries, can it be argued that those waivers are not enforceable? Likely yes, because that may be a public policy reason to indicate that the children's injuries should not, cannot be, that the right to sue in tort because of those injuries cannot be given away by parents. That sort of seems to be the public policy. Now, so what is the conclusion? For a waiver to be enforceable, it has to have unambiguous language. It has to be clear. It should be easily understood by the consumer. As I showed you in the Blue Mountain example, it was very clear. It was very simple. And it said, repeatedly that there is no liability whatsoever for anything you do, negligence, contract, whatever. We have no duty whatsoever. That's the theme of that poster. So, and then, does the waiver cover the specific circumstances of the case? That's important. It's not unconscionable, and there's no public policy concern. So the message that you want to take away is that just because you have signed a waiver, do not assume that all waivers are enforceable. There are many circumstances in which waivers may not be enforceable. So if you are unsure, I think this may be one instance where you may want to go see a personal injury lawyer or somebody who has expertise in that area to confirm whether the waiver at the outset is enforceable or not. And if it's not enforceable, then regardless of the fact that you have signed the waiver, you may still be able to sue for damages. Thank you for watching.